Welcome to the Politics and Media programme. The government's Justice and Security Bill is currently before the House of Lords. One of its most contentious provisions will allow certain evidence to be heard in secret. The government argued that this is a necessary security measure, but critics claim that the new bill is both unnecessary and will shield the security services from effective public scrutiny. With me to discuss the implications of the proposed new law is Anna Thomas, lawyer for Reprieve. Reprieve helped represent Guantanamo detainee Binyamin Mohammed when he took proceedings out against the British government. I'm also joined by Mozam Beg, former Guantanamo detainee and director of Caged Prisoners, and on the phone by David Anderson QC, independent reviewer of terrorism legislation. Welcome to the programme, everybody. Mozam, why do you think this piece of legislation has been brought in, and what do you think the faults with it are?
Well, I know why it's been brought in. It's been brought in because of the discussions the government had between us and the government in relation to the settlement that was given. A large amount of money was paid to the former Guantanamo prisoners for what we believe was complicity in false imprisonment, torture and rendition. But above and beyond that, I think it's clear that although the government said that they don't want to have to do this again in order to protect national security interests, which they say might have to be divulged if this case would have gone further. And clearly what was happening, and the reason why the government wanted to negotiate with us in the first place after spending tens of millions of pounds and employing 60 barristers to fight against us, was when documents were disclosed showing clearly that the British government knew precisely what was happening to myself, to Omar Dagayas, to Binyamin Mohammed and many others in terms of torture, with British intelligence services being physically present in many of the cases. But let's not forget that this is called the Justice and Security Bill. And we know that the concept of justice isn't just one that it has to be done, but it has to be seen to be done. And how can justice be seen to be done in an unseen context, which is precisely what they're proposing? And what we were told at the time was that if we didn't accept the settlement, that they would be pushing through anyway for a similar bill, the likes of which we didn't know in detail up until it was discussed. But we understood that it was being, at its embryonic stages, prepared because of cases like ours, meaning that just as in the case, for example, of the British resident Shaka Rama, who's still there, he maintains that he was physically beaten in the presence of MI5 agents with his head smashed against the wall repeatedly, and that his continuation in Guantanamo is because of partly the British government's involvement, and that this is precisely the sort of case that would be heard in secret, purportedly in the interest of national security.
And let me bring in David Anderson. I mean, David, it's your job to oversee or to look through this kind of legislation and to evaluate it. Where do you think the balance of the argument lies with this particular bill?
Well, as you say, I'm independent. My job is to review the terrorism laws, and I must admit that my first reaction to that one was to be pretty sceptical. I think, though, it's not just about one case. I'd agree with Mozam Beg that the Guantanamo damages case brought it to a head. But I think there is a problem here that is faced in any legal system, which is the problem of litigating and determining a case to which secret evidence about spies, intelligence services, how they go about their business, is central. Now, the ideal, I think everyone would agree, would be to have the case tried on the basis of all the evidence that could possibly be relevant, and to have that tried in a public court, so that not only the parties to the case but the press and the public knew exactly what was going on. I think most people, if they thought about it, would agree also that ideal is never going to happen, because some of these things are secret for a reason. You might, for example, be relying on the evidence of a human source, and if the name or identity of that source became public, then their life could be jeopardized. So sometimes a compromise has to be made. And what's really being proposed here is that there should be some cases in which the interest of all the evidence being before the court should take precedence over the principle of everybody hearing the evidence. So that if you sue the government because something dreadful you say has happened to you, the government's defense relies in part on intelligence evidence. Well, this law would enable that case to be heard by a court that would be in possession of all the evidence. What it couldn't do is release all that evidence to you, because some of it would be secret and impossible to disclose. So it's a compromise, like all procedures are in this area. I'm not particularly happy. In fact, I've been quite critical about the way that the government has struck the compromise. But I do think that there is a real problem here that does have to be addressed.
Okay, Anna, let me just ask you about that. Do you think that, as David says, that there is a compromise to be struck here, or do you think that the whole idea of secret trials is a bad idea?
Closed material procedures or secret trials there's widespread agreement and there's House of Lords authority on it, offensive to the basic principles of adversarial justice, of the principles of natural justice and open justice. So there has to be, I think, a real need, the demonstration of a real need before we change our common law system, which has served us so well for so long and for which we're known throughout the world. It does seem to me as if there is a real dearth of any evidence which demonstrates a need that the current system of PII and the various other procedural mechanisms which we have available to us to ensure that national security is protected, because of course that is right, isn't working properly. Just to link that up with something Mozam said, we must all remember that the Guantanamo case is settled on their merits at a very early stage of things, before there'd been any application for PII or a judge had given any consideration to whether or not the current system would work properly or not.
So Mozam, if your understanding of this is correct, it seems that the origins of this are a bit murky, to say the least, because what seems to be saying here is not that if secret evidence had been given in your case, the outcome would have been different. It seems to be that it just costs too much.
Well, it costs too much not only in terms of finance, but in terms of embarrassment also, and I think that's what the government is trying to, and will be, this will open a door for it, because if they have the option, and let's remember that they already have, there will never be a case in which secret evidence or national security interests will be divulged. That there are already, I believe, mechanisms within Parliament, within the legal system, that will prevent any national security interests and the names of individuals and officers and so forth who should be protected unless they've committed crimes. Because here's the issue: if you're an intelligence officer, if you were physically present, taking part in and tacitly approving the beating of a British citizen or somebody else's citizen, are you then immune from prosecution? Does it mean that you can have no case brought against you? This is what Obama has recently done in relation to some of the CIA agents in the United States of America. And we are talking about civil proceedings here. And that in itself is something that's really unprecedented. Britain, the land of habeas corpus and human rights and freedom, somehow is going to introduce a secret evidence system into Britain in 2012, after countries like Egypt and Tunisia and elsewhere have risen up precisely against this sort of thing. It doesn't make any sense that Britain would be walking into this or sleepwalking into this in 2012.
David, let me bring you back to that point, because, I mean, you say it's kind of realpolitik that this is going to happen, but in actual fact, isn't it an abrogation of absolutely fundamental principles, or principles that have been in British law since at least the 17th century, that the government isn't above the law, that a defendant is entitled to hear the evidence against them? I mean, I'm still a little bit lost about what the argument could be for abolishing those cases, and you might say in the most important cases where they apply.
Well, certainly the government shouldn't be above the law, but I think in an imperfect world, you just have to reflect on the other ways that it is possible to try and deal with this problem of very secret evidence that cannot be put into open court. Now, Mozam Beg mentioned the United States. I've been over there recently. I've been talking to the American Civil Liberties Union. I've been talking to Human Rights Watch. I've been talking to others who try to bring these actions, suing the American government for things that it did wrong in the civil courts. And inevitably they are met with what I really would call sweeping the evidence under the carpet. The administration, and the Obama administration, just the same as the Bush administration, will claim the state secrets privilege, which means all this is too secret to be discussed in the court, and effectively the case has to be struck out. Now, that is one solution to this problem. I would say it's a very unsatisfactory solution because the case never gets a hearing at all. Over in this country, it seems to me if we're going to avoid that possibility, and if we're going to avoid the contrary possibility of the government having to settle a case that it's got very good evidence to defend but which it can't produce in open court, it is useful to have some sort of intermediate procedure which at least allows the judge to have regard to all the relevant evidence and allows the judge to write an open judgment that everybody can read, in which he or she will express their conclusions. Now, there will also have, in a secret case, to be a secret part of that judgment that can only be read by people who are security cleared. That, I think, is inevitable. But to me, the important thing, and I don't want to sound as though I'm defending the government here, because I don't defend the way they're going about this. The important thing for me is that our judges, who I think are independent and very, very good judges, should be the ones that decide which procedure is fairest in the individual case, whether you go the public interest immunity route or whether you go the closed material procedure route. And one of my reservations about the bill as it currently exists, and of course it's still to have its report stage in House of Lords, so it may well be that it will be amended. But one of my reservations is that it gives the Secretary of State too much power to decide when a case will be heard and closed. I think that power should belong to nobody except the judge, and that the judge should exercise that power only if he or she is convinced that that is the fairest way to dispose of the case.
Okay, well, Manna, let me just bring you to 2 points that were made there. One of which David makes that many critics of the proposed bill have made, that this will be a politician's decision, and that the judges will simply be instructed to take evidence in secret. But secondly, also that parts of the judgment itself will not be open to somebody who hasn't been security cleared. So presumably, if somebody is found guilty, then the judgment against them, they won't even know it, or part of it.
Yes, they may not understand why they've lost the case, or there's been some finding against them. That's right. The first point, perhaps, is a very, very important point, that certainly as drafted, the Secretary of State, I think David put it very well himself recently, the Secretary of State pulls the strings. We have been told by the government that the decision, the final decision, will rest now. This is a change from the Green Paper in the hands of the judge who will determine the case, but that's not right. And anyone that reads the bill section, the clause 6 of the bill, will see that there are endless musts in that section. So the judge must grant the application. In certain circumstances, in a nutshell, where there's sensitive material that is said to be of national security, and we all know that the courts defer rightly to assertions of national security. And secondly, it's only the Secretary of State in that section that gets to consider PII and the other procedural mechanisms available. The judge himself will not be able to weigh, as in the old PII system, in the interest of national security with the particular interests of justice and how that should run out in the particular case. That's taken away from him, and he will be forced to order a CMP in any civil litigation if there is a sensitive material which is said to be material that impacts on national security.
I mean, Mozam, so let's imagine the situation that this bill were already law when your case came up. Presumably, from the government's point of view, they must have thought that they had conclusive evidence which would have produced a different result. Say that it had done. Then you would never know what that evidence is and why you'd lost the case.
Precisely, and I think that not only would we not know, our lawyers wouldn't know, and this is really odd and strange, because this wouldn't be the first time that we've been up against secret evidence courts. When we were held in Guantanamo, the commissions there against us again were in secret. The tribunals in secret. Special advocates appointed. We'd never get to know why we're being held. So it would be the second time that we're being held, or we're being held to account by secret evidence. But let me just also tell you that you've got in the UK the Special Immigration and Appeals Commissions, which had the control orders cases heard in the case, for example, of the Libyans. And there we find that all of these individuals were held either in detention without charge earlier on and then after that on control orders based on secret evidence. And where did that secret evidence come from? Gaddafi's torture chambers, and after they were stormed by the rebels, and where the evidence wasn't found in Britain because the British government wouldn't divulge any of it, but it was found by the rebels and Human Rights Watch. And all of this incriminating evidence showed that the British intelligence services was clearly operating and working with the Gaddafi regime. So now all of these cases, Abdul Hakim Bilhaj, Sami Assadi, and all of the former control order detainees who are now off their control orders have all got cases against the British government because we wanted to hide behind secret evidence. And I've just come back from a visit to Syria, where I've met individuals who told me that they were handed over or taken straight into custody in Syria because of intercept calls that were intercepted by British intelligence and handed over to the Syrians and then later to the Libyans. So I think this goes so far and wide that it's going to of course they're going to want to cover this up. This is not about protecting national security. It's about protecting themselves from serious embarrassment for major crimes.
David, I mean, isn't that a vital point, that if we move down this road, then people who both in our own court system and I think in common understanding of millions of people in this country are entirely innocent but have been through this process of rendition, may find their names besmirched a second time by the system in this country and never know why?
Well, I think perhaps the first thing, just to get out of the way, is we talk about innocence and guilt and so on. There is no question of applying these new procedures to criminal cases. So if you're accused of a crime, you're going to hear all the evidence that the jury hears and that the judge hears, and you might think, well, I just think so too. So we're talking here about civil claims. I mean, classically, it's two categories of claim. It's a claim where you might be refused citizenship, might be refused naturalization, for example. Now, the reason for that is something that the intelligence services have on you, which you can't know about. And in order for the court to make a fair decision on whether you were rightly denied citizenship or not, the idea is that a closed material procedure should enable the court to look at all that evidence, even if not all of it can be communicated to you. And there was a case recently in which the judge said that the court cannot fairly review the decisions in this case, this immigration case, without a closed material procedure. And he also said a closed material procedure is the only realistic alternative to the claimants simply losing. The cases in other language become untriable, and that's the American way. You know, you can sue the American government as much as you want, and they say, sorry, there's so much secret evidence in here that your case has become untriable and you lose. Now, the other category of cases, which Moazzam is referring to, is the damages cases, where people claim damages against the state. It's a smaller category of cases, and I think it's more controversial because even the Joint Committee on Human Rights in Parliament, which was very critical of the bill, accepted that it was sensible for some closed material procedure to be available in the immigration context. So we're really dealing here with the damages cases. We're not dealing with people being besmirched or people being found guilty of anything. We're dealing with people trying to get money out of the government. And instead of the court saying, well, we're going to close this case down because it doesn't make any sense to try it because so much of the evidence can't be released into public, what the bill would enable the judge to do, and I say this should only be as a last resort, although the bill doesn't yet say that, is it should be fought to a conclusion. The court will hear all the evidence. The court will transmit as much as possible of the evidence to the claimant, and the court will put as much as possible of the evidence in its judgment. So those control order cases that Moazzam Begg talks about, every single one of them, you can look up the judgment. It's on the web. It's available in a public, open version. Doesn't have all the details. That's in an appendix, which you need security clearance to see. Is it an ideal solution? Certainly not. Is it a useful weapon to add to the judge's armory when the judge is trying to work out how best he can fairly try a case? I think it is.
So, Anna, I mean, is one of your fears that there might be kind of bleed from the civil cases into criminal cases, or cases which are politically sensitive for other reasons? I mean, the review of the killing of Azil Rodney, which was announced on the news today, there's some talk that evidence in that might be heard secretly.
There's a real concern that it may bleed. I mean, primarily I think that's within the civil litigation arena, because the bill is being introduced into all forms of civil litigation, potentially as it's drafted at the moment, and isn't limited to immigration cases or control cases or any other particular area of civil litigation. The concern about it bleeding it extends even to inquests, even though we welcomed, many of us welcomed the amendment in the bill which left inquests out of secret courts, although we'd say that the logic of that meant that really there shouldn't be, there's no need for them and they shouldn't be permitted in other forms of civil litigation. But there is a provision in the bill as drafted which enables the Secretary of State, I think without coming back to Parliament, to expand the scope of the CMP provisions, and potentially that would mean that inquests could be brought in within the scope in the future. Similarly, over the summer we have heard reports of the fact that the very fact that the government, that the state may apply for a CMP may itself be kept secret. So those are just two examples that come to mind. But there's endless scope, I think, for the spreading of secret courts into other areas. Yes.
Mozam, just to put to you the point that David made, that this is this one of cases where you can be found guilty or innocent of a criminal charge, but there are civil cases and for damages and so forth. But does that still not mean that that people who have behaved wrongly, and in the case of the security services, won't be held openly to account?
Well, there are several things that have been proposed and taking place. I've spoken to the police, for example, in terms of a possible criminal prosecution against intelligence service agents who've been involved in rendition and torture. They're speaking to also people like Abdul Hakim Bilhaj in Libya, for whom he believes that the British intelligence services were responsible for his rendition from the Far East. I guess, and also you've got an inquiry, a detained inquiry, which started and then it was scrapped, and now it's going to restart some point again in the future. So what we really do have, thus far we've had successfully to a degree, was the claim for civil damages. Now, if that's taken away and put under the umbrella of secrecy, then we just simply return to where we were, which is there will not only not be any justice, there won't be any justice that will be seen. And again, referring to David's point in relation to the control order cases, well, some of that stuff may be available to see, but what only became available to see was after the rebels stormed the intelligence headquarters of the Mukhabarat in Libya, and there we saw what the British intelligence services and the Gaddafi regime were doing, and it had nothing to do with national security. It's certainly not the national security of the United Kingdom, perhaps the national security of Gaddafi that we wanted to probably defend at that time. And this shows very, very clearly that this sort of law would prevent people like Abdul Hakim Bilhaj and Sami Assadi from seeking justice in the British courts, because the only thing that would be protected, again, not British national security, because it's all out in the open, it would be the embarrassment and the proof that the British intelligence services were cooperating with tyrannical regimes in the torture and rendition of their subjects.
Okay, well, I'm afraid that's about all that we've got time for. So my thanks to Mozam Beg, to Anna Taylor and to David Anderson for joining us on the phone. I'm sure we'll be returning in future editions of the Politics and Media programme to look at the fate of the Security and Justice Bill. But for now, that's all we've got time for. Please do rejoin us in the second part of the programme when we'll be discussing the Channel 4 documentary, Islam, The Untold Story.